Hi there, I'm Annie from Mum Life Australia, and you're listening to the Mum Life Australia podcast, where we combine evidence-based information with practical tips to empower, inspire, and support mums. Today's episode of the podcast is a little bit different. It's all about planning ahead and the importance of having a will in place, something which for many of us is usually in the too hard basket or at the very bottom of the to-do list. The good news is that this episode is all about encouraging you to take action and giving you some tools to get you started on what is otherwise a very sensitive and sometimes even daunting process. Our expert guest, Jacqui Brauman, is the principal solicitor of the all-female law firm TBA Law. Jacqui has written and published In Case of Emergency, a practical guide for young families in the case of injury or death, and Death and Social Media, a guide to your digital estate planning. In this episode, we talk specifically about the consequences of not having a will in place, common misconceptions people have about wills, what's involved in making a will, tips for choosing guardians for children, asking permission to appoint guardians, protecting the best interests of your child, and finally, making superannuation death benefit nominations. What I love so much about this episode is that the practical tips that Jacqui shares actually make it easy to take action. Hi Jacqui, it is an absolute pleasure to have you on the podcast with us today. Thank you so much for joining us.
Great, thanks Annie, glad to be here.
Jacqui, I would love for you to tell our listeners just a little bit about yourself and what you do.
Yeah, sure. So for work, I am a lawyer. I'm an accredited wills and estate specialist, and I actually run my own law firm, and we're a female-only law firm at the moment. I'm also a defence spouse. I've been married to my husband for about 12 years and have been following him around the country for about 15 years. And I suppose now that I own my own business, he's sort of putting my career ahead of his. It's a little bit of a shift in our relationship as well. And we don't have kids. We haven't been able to. And otherwise, we've got a fur baby. We do a lot of running and fairly active lifestyle. We do a lot of fishing on the weekends as well. So that's in a nutshell.
Jacqui, how did you find yourself in this particular area of working with wills and estates?
For the first few years as a lawyer, I was in general practice. So I was doing a bit of everything, working in small firms. It's sort of what you have to do. You just have to service your community. And I was being pushed more and more into doing family law litigation. And that tends to happen in firms where the partners are male and they don't want to do that work, so they give it to the female staff. And I'd had enough of that. Litigation's really emotionally draining, particularly with families, and you never really see them get the result they want. And then, so we're in Sydney, and I worked for a company for a while in-house doing their property and environmental work. And that gave me much more of a business background. And I thought when we got posted again back to Victoria that it was a chance for me to go out on my own instead of go and work for someone else again. So I did. And the business is still a general practice, but I've moved more and more into wills and estates because I want to work with people who want to work with me and get a good result. And I also have seen quite a few horror stories over the years working in various general practices where they didn't really put the focus on the estate planning, but they certainly loved when the planning went wrong because there were bigger fees at the end when they were doing the litigation to sort things out. And it didn't sit well with me to see families go through that. So I think we should do a better job in the first place.
You're all about making a positive social impact, really, is what you're trying to say.
Yeah, it's a nice way of putting it. I am, yes.
So a lot of our listeners will be mums and possibly even dads with very young families. And although you said you don't have a family yourself, having been and you referred to it as a defence spouse and now running your own business, I have no doubt that you do understand the juggle, whether or not that juggle involves children or not. I still feel like you understand that juggle. And when we're so busy, I spoke to a mum this morning even at kinder drop-off about all these balls we need to keep in the air, having just come off the weekend. It's just that there is just so much going on in our really busy lives. So why do you think it's so important for us to really invest not just the time, but also the resources in putting together a plan for wills and estates?
You're absolutely right. This process falls to the bottom of everyone's list because there's so many more immediate things to think about, and people always think, oh, we'll be right, it'll be fine, we'll get to it before it's too late. But the problem is that if it's too late, it's already too late, So someone's been in an accident, or there's an injury, or there's a workplace accident and there's serious consequences, or someone passes away suddenly. And the consequences for the family are huge because not only are you trying to grieve, you're trying to pull together some semblance of a life, but you've also got a legal mess which you don't want to deal with. So there's those aspects, but there's also the risk that the two parents pass away and the kids are left alone. And there's actually a case that really got me into this area where a friend of mine was actually prosecuting a driver who had run a red light, had killed some parents who were walking across the road. They had left their children in Sydney and come down to watch the AFL for the weekend. So they were, they'd left their kids with one side of the family, the grandparents, and were down for a weekend, suddenly dead. And so my friend was prosecuting this driver. It had been about 18 months to 2 years after the parents had died, and the victim impact statements came in, and she was particularly moved by this because the kids had been in and out of family court for the last 18 months because the grandparents didn't like each other on either side of the family, and they were battling over who had the kids and who controlled the inheritance. And I just thought that is not how those kids need to grow up, and it could have been quite easily fixed, really.
Wow, that story sends shivers up my spine as a parent because I can just imagine my family in those circumstances. And to be honest, the first thing I thought when we started just a couple of minutes ago this conversation, I thought, well, surely if something happened to my husband and I, our parents who are both alive, so our children's grandparents, they would just pick up the pieces and it would be sorted. And I mean, for us, we're lucky enough where both sets of parents have an amicable relationship. I have a sibling, and so I would have just thought everybody would pick up the pieces. But it's almost like of weddings. When you have a wedding or there's a death in the family, that's when all of the family politics and comes to light. So is that kind of almost like one of the risks that you think that it's going to be okay, and then in actual fact, after you've passed away, it ends up being quite a mess?
Yes. And to be honest, where people often think that their family will all get along, but really as soon as there's some money involved, it's pretty horrible sometimes what does happen to family members. So you don't want to risk it.
Having worked in this area for a long time now, do you feel like that's the biggest mistake or misconception that most people have about wills?
Yes, that's one of the biggest, that everything will be fine and it'll be easy to work out because they think that laws are clear about what should happen, or they think that their family will have the flexibility to do what their wishes are. But every state actually has different laws about what happens when someone dies without a will, and it's not necessarily what you think. If you have a spouse, you would think that the law would give everything to your spouse in the first instance. However, in most states, the law doesn't say that at all. It says that the spouse gets the first part or a percentage and the rest is divided up between the kids. Now, that can leave a spouse in a really financial difficulty, particularly if there's still a mortgage and they don't have enough funds to pay that off. But it can also leave the kids in a precarious situation because if money's held in trust for them until they're 18 and then all of a sudden at 18 they have this big whack of inheritance, which is not what either parent would want, then inheritance can be blown, they can be taken advantage of. So people assume that things will go easily, but if you take some control now, and like you said, the time and resources to invest into getting it right are not huge in the scheme of what could go wrong. Yeah. So it's worth putting the time in.
And that's actually quite incredible, because I often think about the real big risk of all of this, of not having a will, is really if both parents were to pass away and what would happen to the kids and their money. I had never really thought about what would happen if one spouse was to pass away, and that you've just brought up this whole can of worms, that it's actually even possible that if you don't have a will in place, that the other spouse may not have enough money to live, because the kids would may in some circumstances get the remainder, in which case they can't touch that money. And so there is this money there that you, in your mind, you say would be put aside if anything was to happen, but in actual fact you wouldn't have access to that money even if you needed it.
Mm-hmm. That's
wow,
right.
Incredible. Okay, so if that's the case, I want to know, do we actually need to have a written legal document? Like, can we, if everything is pretty clear, we know what we want, it's not particularly complicated, can we just put in place a written document, or do we actually have to go sit down with a lawyer and pay what I imagine is going to be a relatively large expense, and you can clear that for me? But do we need to do that? Is it more of a formal process that we do need to follow?
You do need a formal will. So there are certain things you have to do to make sure that the will is valid. You probably have seen will kits, though, at the post office, and various insurance companies send those out for free as well. And those can work in simple situations, so long as you follow the guidelines and make sure that you sign it correctly so that it is valid. Because if you just leave some instructions at home, it's not valid, and those laws that I was talking about before override whatever wishes you may have if those wishes aren't validly set out. So you do at least need a basic will, and then if you want to do a whole underlying set of guardianship instructions and leave that at home, then that's fantastic. And that's actually a process that I go through as well with people. If they want to leave a set of instructions for guardians, it's a whole separate thing you can do from your will. But, at least have that legal will in place. And look, you can get the will kits. I think they're about $25. You can do an online will, and those are generally under $100. If you go to a solicitor, so the lowest end price for a will is probably between $250 and $350. So I'll do a simple will for $350, and that's each. So it's not a huge outlay. But then if you're looking at something a little bit more complex, you are looking at, $1,000 for a couple to get everything done.
Okay, well, I mean, the fact that it starts off at $250 to $350 is actually quite incredible. I didn't think it was going to be at that end of the spectrum, but I guess the point is to just have something in place.
Yeah.
Especially now, we just spoke about guardianship. I think, especially when you've got really young kids, it's almost like an even bigger issue for me, I feel, as a parent, because when your children are younger, there's a longer period of time for them to require guardianship. Mm-hmm. So when you're instructing or you're advising people who come into your office or speak to you about putting together a will and they have children, what are some tips for choosing guardians? Because I think about it in my own family circumstances. There are my parents, my husband's parents, who are both over the age of 60. I have a brother who has his own children and his own family. But other than that, in terms of immediate family, we don't really have anyone else. So I think the most difficult part of the process for me would be, how would we choose who those guardians should be? And if there's any sort of tips for choosing the most appropriate personal people?
What I say to people first up is that we automatically think that it should be family that takes care of our kids, but it doesn't have to be. Because like you said, if your parents are going to, be on the older end of things by the time your kids get to 18, you might want to think about someone in the generation below. But then you're also thinking, okay, it might be too much of an obligation or a burden to another family member who already has a whole brood of kids. So how do you juggle that? So don't just exclusively look to family. Do think of friends as well, because in bringing up your children, you will have no doubt a set of values that you want to stick to, which will be along the lines of what sort of education, what sort of extracurricular activity, how they're punished, all sorts of things like these. And if your friends are actually more aligned with your values than your family, then look to friends, have the conversation with them, because although you think that it might be too much of a burden, in fact, they might be honoured and do the same in reverse in their wills as well, and could bring the friendship closer. So that's the first thing that I talk about in terms of friends and family being guardians. Then the other thing that I talk about as well is that appoint your first preference, and then you can have a backup, and you can have a backup for your backup. So don't think that there aren't, a flow down of possibilities in case it won't work out, because the primary guardians you appoint might be, say, your brother and his spouse. But then if something should happen to your brother, or if that marriage doesn't last, you might not want your children to be in that scenario. So then you'd want to back up, and then you might want to back up for your backup as well. So there's so many little things to think about, but don't think that you're so restricted. And then the final thing is, you might think that it's such a burden to appoint someone as a guardian, but don't think of it in terms of financial burden, because if your estate is liquid enough, and it probably will be, some of those funds can be used for your education, for the education and maintenance of your children while they're growing up anyway. And you can specify how that's to be used, and have control mechanisms in it so it doesn't just get eaten into too much, but it doesn't have to be a financial burden on your guardian to bring your kids up either.
There's some really great tips there. So don't just look at family, but also consider friends and anyone else that might share similar family values. Consider backups. So you might have a primary guardian, but then other backups in other circumstances, and don't consider it a financial burden.
Yep, absolutely.
And once we've done that, do we need to ask permission? Do they need to know that they are in fact a guardian?
I think it's really important to have the conversation, but it's not essential. You don't have to have their permission to appoint them. And if you don't have the conversation and something does happen, it can be a big shock. And it's something actually that they don't have to do. If you've got a backup, you can have words to the effect of, if they're unable or unwilling to do it, then the backup is such and such. So if you haven't had the conversation, they've got a get out of jail free card, so to speak, in there. But I think it really is crucial to have the conversation about it.
Have you ever had scenarios where perhaps people might choose to have co-guardians? Does that ever happen? So perhaps you might have two very close, if you happen to have two sisters, for example, and they lived in a very small community, they lived near each other, and you chose to have them as co-guardians, or have one care for them in their everyday life and the other be more in a role of looking after their finances or something like that. Is that a scenario that ever comes up?
Yes, it is actually. And I did something last week for someone similar, because they really wanted the parents, but they were worried again about the parents' health in the long term. So they had a sibling in there as well, not as a backup, but as a co-guardian. So it was all three together, and then they could work out between themselves who the kids were actually going to be with. But then you brought up an interesting point there as well about the management of the finances. So the guardians aren't necessarily the ones that manage the finances either. The executors in your will are the ones that usually end up being the trustees of the funds for the kids. So generally, I would recommend to someone that you have a crossover between the guardian and the executor, but you also have an independent person in there as an executor, so that the guardian doesn't have full control of the funds and just, like we were talking about before, potentially whittle it down and waste it. So you've got an independent person there who can decide whether those funds are reasonable or not.
That's a really, really good point, because one of the things I was thinking as we were talking was, what if my partner and I, or my husband and I, we can't agree on a guardian, but having that ability to have the two roles that do cross over might be a really good compromise. So if there's a family member we want to have heavily involved in our children's lives, but we don't feel comfortable with them in the day-to-day care of our children, and then there's another member of the family where we would prefer for them to be living with, it might be a good way of finding that balance between having both involved, but without either of them doing all of the brunt of the work. So having that balance between the two.
Absolutely.
So once we've actually chosen the guardians, is there any way we can protect our children's best interests? So you've already mentioned there that having that crossover between guardian and executor is a good way to be obviously caring for their financial interests. But is there any other things we need to think about in terms of guardianship to make sure that their best interests are being protected once we do pass away?
In wills, it generally only looks at their financial best interests. So it's the appointment of the executor and making sure that appropriate trusts are set up that would take care of financial interests. So just touching on that for a second, if your kids are well and truly under 18, what's set up automatically is a minor's trust in a will. So it's held on trust till they're 18, or you can extend that age, and I generally recommend people extend it to 25. So it's held in a trust until they're 25. But there are other sorts of trusts you can set up which protect your children's inheritance in the long term as they come to adulthood as well. So in terms of financial protections, there's far more in wills than anything else, because we were talking briefly before about the values of the guardians and how you want your children to be brought up. Unfortunately, in wills, all you can do is put really wishes about how you want your children brought up along the lines of your values, or you can have a separate document like the instructions to guardian, because it's not actually binding on the guardians as to how they bring your children up. So that's why it's so important to choose guardians that are aligned with your values and that you know will stick as close as you would like to how you want them brought up.
Probably also, you mentioned that you would always recommend that people speak to the people that they're choosing to have as guardians before they actually make that choice, because I guess if you knew that those wishes were binding, then you would be happy to do that, because you would just think, well, if they don't want to if they're not going to do as our wishes, then they'll just forego their guardianship, and then hopefully we might have a backup who might be willing to step in. But I guess if those wishes are not binding and we have that conversation before we choose the guardians, we can actually prevent that entire situation, and we can actually know that the person who is going to be the guardian is going to be looking out for those wishes that we've put in. So basically what you're saying though is that those instructions to guardian, no matter what we do, so for example, if one of my wishes was that my children had to, let's say had to go to a private school, private primary and secondary college, for example, there is nothing that would require the guardians to do that. Even though their financial interests are being protected, my wish that they go to a private primary and secondary college wouldn't be binding. Is that correct?
Yeah, that's correct. And look, probably the best thing you could do is in the will actually make a financial direction that the school fees can be paid for, and make a specific direction about, you know, the range and what sort of schools you'd be happy with. But if the guardian ultimately chooses no public school, then those funds don't have to be needed anyway. So no, that's why it is crucial, like you were talking about, to not only have the conversation and make sure the guardian's comfortable, but screen them in terms of how willing they are to follow what you're after for your kids' development and growth.
And I guess, the other aspect of it is that you also, I guess you might need to also add some flexibility in there as well, because at the end of the day, if the guardians that you've chosen have their own family, then you obviously don't want your child or children to be living an almost separate life to the rest of the family. They have to be feeling as though that's their new family, I guess. So from some perspective, I guess you want to allow them some flexibility within I guess, your values and the rest of it. But I guess if you've chosen the right guardians for your family, then perhaps that will all just flow through.
Yeah, that's right. And you'd hope that whoever you chose has similar values for their own children, and so it would just flow through and they'd all be, brought up in a similar way.
That's fantastic. I think that is so much really useful information, Jacqui, because it does seem like this is a really, when you think about it, it just seems like it's going to require a huge investment of time and resources. And although this whole issue of guardianship requires quite a bit of thought, the fact that it is something that you can work with a lawyer, and even the tips that you've shared right there, they even simplify it even further. So knowing that this is something that at the very easiest level of the spectrum, you could just go and get a formal will kit, fill it out, versus the other end of the spectrum where you could actually sit and speak to a lawyer and think about all the other perhaps complexities of it. You've really sort of boiled it down to the main things that we do need to think about. So is there anything else that you think we need to think about, or anything else that you'd like to share?
Look, I just think that it's so crucial when children are young to have this done and not just keep putting it off. And so the executor appointments and the guardian appointments are the primary things you need to think about, and just put the time into getting those people right. The only other thing you need to think about as well is your superannuation, because quite often it's the biggest asset that you'll potentially have, particularly if the house still has a high mortgage on it. Superannuation has usually a death benefit insurance policy in it of a couple of $100,000. So you do want to make sure that super gets to where you want it to go as well. And super actually doesn't follow your will. So you do have to make sure you do your nominations on your super fund. So get that done at the same time. And most super funds just have the form downloadable from their website. So it's your binding nomination form, and just get that done at the same time as you sign your will.
Oh, fabulous. So that's another tip there, is that it's not just about your will, but it's also about having your superannuation death benefit nomination in place, so that particular asset also gets sorted out upon your death as well.
Yep, that's right.
That has been amazing. Thank you so much, Jacqui. I really appreciate you coming on to the podcast to talk about this. I know it's something that we don't often want to think about, and when we are so busy juggling everything, it's the last thing on our list, on our to-do list, but it is so, so, so important, whether or not we have kids, but especially if we have kids also that need to be cared for once we do pass. It is something that we need to consider. So, Jacqui, if there are people listening to this and you have triggered them to take action, where can they go to find you, or where can they go to find resources so they can make this finally happen?
There is a lot online. I also have a couple of books you can download from my website for free, and I'm usually running a webinar at any particular time, so there's usually a link to a webinar as well if you want more information. So all of that sort of stuff's free. In every state, you've got your state trustee or public guardian, so they've got a whole lot of free information you can get from them as well. But my website, if you wanted to reach out and contact me, is tbalaw.com.au, and my email address is on there as well. So that's, happy to answer email questions for anyone who has any.
Fabulous. Thank you so much, Jacqui. And for all of our listeners, we will put a link to Jacqui's website, as well as links to those free books, which are amazing resources as well, on our show notes for this particular podcast episode. And we'll also link to a couple of those websites that help with the resources for each of the states, so that if you do need some more information, you can go out there. But if you're ready to take action, you know exactly where to go. Thank you so much, Jacqui. I really appreciate your time.
You're very welcome. Thanks, Annie.
Thanks for tuning into this episode of the Mum Life Australia podcast. You can find all the additional resources, including links to Jacqui's free downloads, on the show notes at www.mumlifeaustralia.com. And don't forget to join the Mum Life Australia community on Facebook, where you can have all your questions answered by our tribe of experts and our podcast guests.